it that it is the supreme law of the land. Federal judges and justices are nominated and appointed by the President of the United States and confirmed with the advice and consent of the Senate. At the beginning of a trial of a civil or criminal case in which a jury will decide the verdict, the process of questioning potential jurors is called the voir dire. That's French and it means to speak the truth. At trial, the process whereby a defendant's attorney would question the plaintiff's witness is called cross-examination. Now notice that it works in the reverse. If the plaintiff is questioning the defendant's witnesses, which happens later in the trial, that's also a form of cross-examination. Appellate courts have several things they can do to lower court decisions. Among them are they can affirm them, which means agree with them. They can reverse them, and they can reverse and remand them. I actually was involved in a case where there were two defendants, went to the state Supreme Court. One defendant was reversed entirely, no new trial, no nothing. He was free to go. And the other one was my defendant, and his decision was reversed but remanded for a new trial. Jill Kirby files a suit against Antonio Carvello in federal court. The document sets out the defendant's responses to allegations in the plaintiff's pleading and any and all affirmative defenses and any and all counterclaims is called the answer. Peremptory jury challenges are limited in number, and you also can't discriminate based on race or gender. Those are the only two cases the federal courts have ruled on so far, race or gender, about discrimination in peremptory challenges. Attorney's fees, where the attorney obtains a certain percentage of the damages awarded in the case, are called contingent fees or contingency fees. The burden of proof in a civil case is what? The burden of proof in a criminal case is what? According to the U.S. Constitution, U.S. Supreme Court justices and all federal judges serve during good behavior. It doesn't actually say for life in the Constitution. It says during good behavior. And I know even the website for the Supreme Court says they serve for life. So what do they know? Chapter 4, Ethics and Business Decision Making. 6 questions. Ethics is the study of what constitutes right and wrong behavior. A common ethical dilemma faced by management in big corporations typically involves the effect that its decisions will have on the stakeholders, is what the book says. So who are the stakeholders? They are the employees, probably like a decision like having to fire a bunch of employees, the community where they live, vendors and suppliers if a plant's going to be closed down, stockholders, even customers and clients are all stakeholders. Suppose that a company suggests to its employees they apply the categorical imperative. You need to be able to recognize a categorical imperative in a multiple choice ABCD type question. So what is it? Well, it's a bit wordy, but it's evaluate your actions in light of the consequences that would follow if everyone, at work in this case, acted in the same way. Well, compare that to a utilitarian perspective. Again, kind of a mouthful of this philosophy, but again, we can shorten this one to the greatest good for the greatest number. But it says an action is morally correct when among the people it affects, it produces the greatest amount of good for the greatest number. All right. In chapter 1, but we actually talked about it in chapter 4, there was a discussion about different ethical philosophies of law. Where do we get our law from? And one of the schools of thought we studied on this was called the positivist school. This would be like some kind of a totalitarian government or something, where the law is the law, there's no such thing as natural rights, and whether a law is bad or good is irrelevant. Questions of corporate social responsibility, business really, corporate social responsibility, involve the extent to which a corporation has ethical duties beyond those mandated by law. You remember my little chart where I had illegal activity at the bottom, an activity that was legal but still unethical. That's what we're talking about. We have to consider that, oh, it's legal, yeah, but it might still be unethical and maybe you shouldn't do it. Chapters 5 and 7, Constitutional Law and Criminal Law. A little bit of criminal law. Constitutional right of privacy, something we didn't quite get to on the test involving the constitutional law chapter, but we talked about it later. The constitutional law right of privacy was created by the Supreme Court. It's not in the Constitution specifically or expressly. Therefore, it was implied or derived by the judges on the Supreme Court, justices on the Supreme Court, from several constitutional amendments. The written document adopted by the Constitutional Convention of 1787 became known as the U.S. Constitution. In fact, they didn't really call it the Constitutional Convention at first, but anyways. The Bill of Rights is the first 10 amendments to the United States Constitution. Those are two of the easiest questions on the whole exam. You'll be surprised, but some people will get some of those wrong. In Katzenbach versus McClung, the famous Ollie's barbecue case, the owner of Ollie's said that he was not engaged in interstate commerce, and the court said that he was. That even the activities that he had, which were intrastate, meaning within the state of Alabama, had an effect or created an interstate activity, which was he was buying materials and supplies and food across state lines, even though his customers weren't from the state. He did not want to comply with the Civil Rights Act of '64, and the court said he had to. Now, the two answers to this question in here, and two of the choices in the multiple choice, one of them uses the word intrastate, but the court ruled that he was engaged in interstate commerce, even if he physically didn't cross state lines, and neither did his customers. His food did, and his supplies did. Freedom of speech, we studied that, what it protects and what it doesn't. We know that it protects some interesting kind of speech, including KKK rallies and neo-Nazis and things like that. And we even found out that it covers symbolic speech, like flag burning, and things like commercial speech. But what we did learn is that there's some things it does not protect, but some of those are hard to define. Like it's very difficult today to define what's pornography or what's obscene. So one thing it clearly still does not protect is defamation. One of the exceptions to the requirement that the police first obtain, the government, including the police, must first obtain a warrant before conducting a search and seizure is the plain view exception. The plain view idea being that in your car, or in your house for this matter, if they look in your car and they see a open container of alcohol, or they see the butt of a gun or a knife, that's a concealed weapon, or they conceal a marijuana roach in the ashtray, then all of those things are bad, bad, bad. All right, so plain view exception. According to the exclusionary rule, evidence obtained illegally by the government cannot be introduced or used in a criminal trial. Therefore, it's excluded from evidence. All right, chapters 9 and 10. 36 questions. All this is new to you. This is all on contracts. And along with chapter 16, which is 15 questions, the total is 51 questions, or 50% of the exam. At a minimum, a contract consists of a legal agreement between two or more competent parties where consideration is exchanged now or in the future. Now, you'll notice that's my definition. It's a modification of the one in the book where the part about consideration is mentioned. There was an example in the book of where a steel company had ordered some coal. And the coal company had brought the coal and delivered it and left an invoice, but the steel company hadn't paid for it yet. So we say that as to the steel company, that part of the contract was still executory. As to the coal company, they'd done everything they needed to do. Their part was fully executed. So I'll give you a fact scenario similar to that, and you'll have to say that, whether or not it's executed or executory. In order to have an offer, the outline for an offer, and to be effective, the offeror must objectively intend to become bound by the offer. The terms of the offer must be reasonably definite, and the offer must be communicated to the offeror. If your uncle said he's going to give you $500 for Christmas, and then he doesn't give it to you, his promise is not binding because you haven't given him any consideration in return. In a bilateral contract, there is a promise for a promise. In a unilateral contract, we say there's a promise for an act. The promise in a unilateral contract is an offer. It's like a reward, for instance. And the act part of it is the acceptance. In other words, the only way you can claim the reward which is offered is to actually go find the lost dog or provide information leading to apprehension and conviction of a criminal or something like that. Okay? An oral contract for sale of an interest in real property is unenforceable under the statute of frauds. And that's what the book mentions, but North Carolina uses the word void in the statute, so I have to throw that in. Unenforceable or void under the statute of fraud. Let's say that you and I are negotiating for the purchase of your Fiat, and I go, I've been thinking about buying your Fiat, and you said, actually, I've been thinking about selling it. And I said, well, what would you want for it? And then you think, I think it's worth 20 grand. So then I go into this thing about, well, I got to do this, that, and the other to raise the 20 grand. So far, we have nothing. We don't have an offer, we don't have an acceptance, we don't have a contract. These are all just preliminary negotiations and future discussions, future intent. Lucy versus Zimmer in your book is the classic case deciding contractual intent. Now, we often want to think of it as being a capacity case, but it's not. It's all about them kind of messing around with each other because they were drinking. And so it's an intent case, not an intoxication case as far as capacity goes. The charging of excessive or illegal interest on a loan of money is usury. Now, I promised you I'd put in all the answers would begin with the letter U, and that's what I did. So, knowing that it begins with U won't do it. The following, which will automatically terminate an offer prior to acceptance. We studied 7 versions of that. 7 things that would automatically terminate an offer prior to acceptance. So I will give you a list of those Roman numeral type question. You have to pick out which ones are in that grouping. Next question involves a minor. Remember, minors who enter into a contract with an adult can avoid or disaffirm that contract, with some exceptions, within a period that's reasonable after they become an adult. So let's say that this minor makes a deal and then changes his mind the day after his birthday when he becomes an adult. Is that within a reasonable time? Certainly, yes, it would be, and he can set the contract aside. Generally, under the common law, a contract between a U.S. citizen and a non-resident alien from Mexico is valid. And that's something the book doesn't mention about aliens, so I kind of threw this in. Notice that some states have changed this or are trying to change this, and there's a big controversy about illegal immigrants from another country and whether or not, for instance, employers can hire them. So some states, some localities, some counties, some city ordinances have tried to change this, but under the common law, a contract between you and somebody from another country is still valid. The equitable remedy for misrepresentation or fraud is rescission, not types of money damages. Next question is kind of a thought-provoking one that I came up with. Basically, it says various people who are involved in some of these things we've studied, when can you sue and get your money back if the contract's completely executed? In other words, if it's already happened and you're just within some window of time after, like a statute of limitations. For instance, if somebody pays an unlicensed contractor for work over the $30,000 limit, can they get it back? The answer is no. You didn't have to pay them, but once you pay them, you can't get that back. But on usury, you can get it back. In other words, if you get a loan, pay it back with the excessive interest, you still have maybe a year or two, whatever the statute of limitations is, to sue and get that money back. A counteroffer, we learned, is a rejection of an original offer and also a new offer. And the people change hats. In other words, if I made you an offer on your car of 20 grand and of 18, and you countered with 19, then you are the one making the offer to sell to me at 19. And I now have the right to accept or reject your offer. A reward published in the classified section of a newspaper is an example of an offer. Most publications of ads in the paper are not offers, but are solicitations or invitations for offer. A reward is also a type of unilateral contract where the offer is made to, I'll pay you if you find my lost dog, and then you have to go out. The only way to perform that contract, and therefore your promise for an act, is to find the lost dog and claim the reward. Among the various types of pre-existing legal duty, there were 2 mentioned in the book, as pre-existing legal duties, and they're slightly different. One was that a sheriff has a duty to arrest any fugitive in his or her jurisdiction. The second one was that a building contractor who wanted more money for a fixed price contract because the cost of materials went up. Normally speaking, unless the court allows unforeseen difficulties, the contractor is stuck and has to perform the contract for whatever he agreed to perform it for. Okay? The various types of damages that we studied: compensatory, punitive, liquidated, nominal. The one that involved indirect or special damages is consequential damages. Suppose a lady is adjudicated incompetent by a court. So there's no question about her competency. She is incompetent. But somehow she manages to slip away, and then she runs back to her house and has a big yard sale or something, and or purchases something, and that sort of thing. All her contracts are void. All of them are void. All right. Let's say that I tell you that I want to buy your Fiat, and I'll give you until 5 o'clock today to accept my offer of $18,000. Meanwhile, you've got till 5, and at 3 p.m. I call you up and tell you I'm withdrawing my offer, revoking my offer. And you go, wait a minute, you can't revoke your offer. You gave me until 5 o'clock. That doesn't matter what I gave you. I still have the right to withdraw my offer at any time prior to your acceptance. Landlords are required to mitigate the damages in the event of breach of a lease agreement by their tenants. Unconscionable contracts are those that are fundamentally or grossly unfair or oppressive to one of the parties to the contract. In order to prove undue influence, we have to establish something called a confidential relationship. The one who's unduly influenced, whose mind is bent somehow or changed, or it's not their free will by this other person, that other person has a confidential relationship. Usually it's the person with that relationship that is benefited by the deal, or by the undue influence in the deal. Suppose an owner and a builder agree that it's going to be difficult for damages to be determined on construction of, say, a deck on my house, so I can have some people over. Or I'm a business and I'm going to have a grand opening. So obviously I'm going to lose business if you don't have it done in time. So you and I agree that I'll charge you $1,000 a day if you go beyond the deadline. This is something we call liquidated damages. It must be reasonable and not excessive, considering the amount of the contract and difficulty of estimated damages in the event of a breach. All right, next question. I'll not read you the exact question, but I'll kind of give you a version of it that I gave in class. Suppose I'm decided to paint my house, and I'm painting it this unbelievable color, chartreuse, let's say. And my neighbor comes up to me and says, my neighbor's Walker, by the way. Walker comes up to me and says, I hate that color, it makes me physically nauseous. Would you consider painting it another color? And I'd say, well, make me an offer or something like that. And so the other guy, my neighbor, Walker, says, look, I tell you what, I'll pay to paint your house a color you and I can agree on, that we both like okay and is acceptable to us. We'll go down to the paint store and do that. Now, what have I given up in return? In other words, is there consideration? Walker has given me the money for the paint, so that's his consideration. What am I doing? I'm giving up the right to paint my house the color I wanted to paint. Okay? Foreseeability is important in negligence, we found out, in proximate causation. But we also know that foreseeability came up a couple of times in contract law. Once was in the pre-existing duty and unforeseen circumstances case involving the contractor who didn't foresee, some unforeseen problems with his contract or the amount of money he had. The other was a factor in consequential damages. The Hadley versus Baxendale case, remember? Did Baxendale foresee that that company would have to shut down and lose money and lose production? Courts look at covenants not to compete and will actually usually uphold them, but they have to find that they're reasonable in time, reasonable in geographical scope, and this is the part I added, not any greater a restriction than is necessary to protect the legitimate business interest. In other words, the court want them to be narrowly defined. They don't want them to be too broad. Now again, I was unsure about whether all that's really in the latest book because they took a case out that was in there that said all that last time. And that case isn't in there anymore, so that's the reason I brought it up. When one of the parties to a personal service contract dies, then there's a type of impossibility of performance. And their estate is excused from performance of the contract, and the contract's generally discharged. Now, what if they're merely rendered incompetent temporarily? Well, then there may be a temporary impossibility, but that could become permanent. No contract exists in mutual mistake law when there's a mutual mistake of a material fact, and only in that case. Unilateral, doesn't matter. Opinion, value, doesn't matter. We don't set the contract aside. So the rule is easy. No contract when there's mutual mistake of material fact. Applying them to the facts of the cases is what's hard. Speaking of that, when we're talking about undue influence and mistake and fraud and all that, we said that voluntary consent, which in the book is also known as genuineness of assent, can be used to set a contract aside because there's no meeting of the minds. In the mistake case, there was no meeting of the minds because the parties were agreeing about different things, and they didn't know what they were agreeing to, so they didn't agree on the same thing. In the undue influence case, it's a case of somebody's mind being manipulated by another and not doing it of their own free will. The tort that we studied that also involves contract law and can be a crime is fraud, sometimes known as misrepresentation, but the more serious version of that is fraud, so I think we'd use fraud for the criminal side, and then it usually involves a contract and it's a tort too. Contracts can be charged in a number of ways, and among those we studied bankruptcy, impossibility, expiration of statute of limitations, frustration of purpose. Suppose you receive a credit card in the mail which you never requested. The offer states, well, we're going to charge you $50 annual fee if whether or not we hear from you and whether or not you use the card or you activate it. That silence on your part, if you don't respond, is not a binding contract. You cannot be charged that fee. You've not agreed to anything. Now, if you do use it or you do activate the card, then you may have agreed to the terms there. But if you don't accept, you don't have a duty to respond. Termination of an offer and termination of a contract can happen in a number of ways. Again, we studied the 7 ways that you can terminate an offer. And the point is that some of those can also terminate a contract and some maybe not. For instance, if you die and you and I have a deal on your car, I can still make your heirs sell me your car. But I cannot buy your car even if we have an offer or if we have an offer and an acceptance and therefore a contract if you wreck it before the final performance of the executed contract. In other words, before you deliver it to me. So that's destruction of the subject matter. Mailbox rule has another name. It goes by the name deposited acceptance rule. And that ought to kind of help you remember the mailbox rule because it has to do with depositing the acceptance in the mail. Chapter 12, we didn't get to chapter 13, 9 questions on torts. When Ford used the voice of someone who sounded like Bette Midler in a Ford commercial without her permission, Ford committed the tort of appropriation. Next question is a repeat of the one from your earlier exam involving proximate cause where the guy crashes into the electrical pole and the guy at the hospital dies because of it. Again, you can possibly have actual cause, but if you don't find actual cause, you never go to proximate. So the answer that most of you put, proximate cause but not actual, can never ever be the correct answer, no matter what the facts are. Next question is similar to one on a prior test. Remember the little old lady in her bedroom and she shoots the intruder? Well, this is similar, but it's a different fact scenario. And this kind of goes back to what we know about the self-defense rule and the castle rule about defending yourself. So this is a little bit of a thought-provoking one here, and you'll have to come up with your decision on what it is. The outline that we had for negligence in the book was that if we have to prove, a plaintiff would have to show a breach of duty and a duty of care that's been breached, an injury, loss, or damage to personal property, and actual and proximate causation. Now remember, if you can't prove actual, you don't have to prove proximate because you lose your case. In Paul's graph, speaking of which, she lost her case because the court ruled there was no proximate causation. They definitely saw a duty of care and a breach of that. I'm not sure it was a duty toward her. They never did really adjudicate the issue about why the scales fell down near her. But anyway, she lost the case because when the guy's suitcase blew up, the court said that was not foreseeable and there was no proximate causation. The landmark case involving intentional interference with a contractual relation is Lumley versus Guy. Remember the two opera house owners in London and the opera singer that went to work for Mr. Guy instead of Mr. Lumley. When a public figure is defamed in a newspaper or a magazine, they have a greater burden of proof because they are public figures. They can respond to press and things like that. They're required to prove that the magazine not only uttered a false statement about this person, but that they made that false statement with actual malice. In other words, they didn't just write something that a reporter told them or an informant told them and it turned out to be false. They knew it was false and they published it anyway. Suppose that a girl accuses her boyfriend of committing an assault on her. What is an assault? Assault is defined in the tort law as an apprehension or fear of immediate harmful or offensive contact. Now I know the book left the word fear out some, but it used to be in there. And there can be a difference there. But the main thing is the immediate harmful or offensive contact, not something in the future. Contributory negligence as a defense in tort cases based on negligence is a complete and absolute defense. In other words, Stella Liebeck would get $0 in North Carolina and some of those particular types of cases. The reason I put this in here is because North Carolina is still one of the few states that has contributory negligence. Next chapter, chapter 16, mortgages and foreclosures after the Great Recession. This is 15 questions, and along with chapters 9 and 10, which is 36, is a total of 51 or 50% of your test. The borrower or debtor who gives the lender a mortgage is called the mortgagor. It's interesting to note that just yesterday I got a document to review from a lender in Florida, a private lender. And they'd had an attorney in North Carolina rewrite one of their mortgages and change some of the wording to make it more like a deed of trust. And every place they put the word mortgagor in, they meant to put mortgagee. And every place they put mortgagee, they meant to put mortgagor. I think maybe that attorney should have taken my test if they don't know the difference. For a real estate purchase, the difference between the purchase price and a new loan is your down payment. Now later on, if you refinance, we say, or if you're going to, look at your property, you say, well, I owe this and it's worth that. The difference, we call that equity. So that's another question later. But at the time of purchase, what you put down is the amount that's necessary over and above your loan amount. All right, a sale of real property for less than what a seller owes on his or her mortgages is a short sale. And a short sale is basically where the idea is that you can't pay it all. You may or may not get a deficiency from your lender if your lender lets you close. The acronym ARM stands for Adjustable Rate Mortgage. The real estate pledged in a mortgage or deed of trust is the collateral. Monthly payments for a fully amortized loan include both principal and interest. Usually the amount of payment remains the same, but the amount of interest on each payment starts to decrease over the life of the loan and the principal starts to go up, but the total payment remains the same. A prepayment penalty is a penalty or a charge for an early payment of principal. Most of the time they're not allowed in most residential loans. The lender's postponement for a limited time or part or all of your payments on a real estate loan is known as a forbearance. Probably any loan, but certainly a real estate loan. A deficiency judgment is a judgment against the borrower for the difference between the loan debt that they owed and what it's sold for. In other words, if it's foreclosed and the bank doesn't get enough for it, then they can come after you for the deficiency. If it is sold on a short sale, they can still hold you responsible for the deficiency. And if you don't pay it, they'll sue you. Okay? The right of redemption that comes after a property is sold in foreclosure is called the statutory right of redemption. The one that comes up to the day of sale is called the equitable right of redemption. Two types of foreclosure actions are judicial and power of sale foreclosure. The difference between what you owe on real estate and the market value is equity, as I mentioned earlier. A borrower will be required to purchase a certain type of insurance when he or she borrows more than 80% of the value of a residence. That's called private mortgage insurance, PMI. A subprime mortgage is defined in your book as a loan made to a borrower who does not qualify for a standard mortgage due to poor credit score and or high debt-to-income ratio. A mortgage recorded first at the courthouse has priority over a mortgage recorded later. Let's say we want to reverse that for some reason. You're refinancing one and you want to keep the other, but you want it to be in second position. In order to make the first one recorded inferior or secondary to the latter one, you have to subordinate it. File a subordination agreement. Chapter 17, 18, 19, that was business entities, sole proprietorships, etc. In North Carolina, where a partnership owns real property, same question we had on an earlier test, everybody did so poorly on. Remember, if a partnership owns real estate, a corporation owns real estate, a limited partnership owns real estate, the LLC owns nothing but real estate. Whatever that's the case, your ownership as an owner in that company is a personal property interest. It's an intangible personal property interest. Same question. Another same question. In North Carolina, where we don't have the latest version of RUPA, the Revised Uniform Partnership Act, there's nothing in our law about partnerships filing anything with the Secretary of State. So in North Carolina, the business organizations which are required to file something with the Secretary of State, and by the way, partnerships, I think that's only voluntary under that version of RUPA. We don't have that. Is limited partnership, corporation, limited liability company? A question off an old test. Another question off an old test. Of those documents required to be filed with the Secretary of State, there's one that has to be done internally or written document in an LLC. That's the operating agreement. A limited liability company is owned by its members, not stockholders. Double taxation is usually associated with C corporations. In a general partnership where all partners are natural persons, in other words, they're all flesh and blood, they all have unlimited personal liability. In North Carolina, it's possible to have a corporation, sole proprietorship, or LLC that's owned by one owner. In North Carolina, the document filed in the county where a business does business under some name other than its own is the certificate of assumed name, or assumed name certificate, and that even applies to sole proprietorship. Normally, day-to-day operations of a franchise is left up to the franchisee. A corporation that is incorporated in one state but doing business in another is referred to in the second state as a foreign corporation. A person who signs and files articles of organization with the North Carolina Secretary of State is the organizer or the member. It used to be just organizers, now it's both. In small, closely held companies, including corporations, general partnerships, limited liability companies, and maybe even limited partnerships, there is a clause or a series of paragraphs that we put in, and I refer to these as buy-sell agreements because they restrict the transfer of interest in the company. Now, I will tell you that when I do this, in the document, let's say an LLC operating agreement, it doesn't actually use the word buy-sell agreement. It calls it restriction on transfer of interest. And it can be in the operating agreement in corporations, it'd be in the bylaws or something. Nonprofit corporations are sometimes tax exempt, sometimes they're charities which are tax exempt, sometimes they're domestic, sometimes they're foreign. But, if I said all nonprofits are any one of these, that's not true. So it would be a good none of the above type question. Finally, Chapter 19, 5 questions. An agent for an undisclosed principal, or partially disclosed, but undisclosed is the question, is personally liable for their torts. That's just part of the general tort law and the agency law. But they're also liable for contracts entered into on behalf of the principal if the principal is undisclosed or partially disclosed. Under the doctrine of respondeat superior, a principal employer is vicariously liable for torts committed by an agent employee within the scope of employment. Well, what about independent contractors? No, the employer is not liable for torts committed by the independent contractor in the performance of the contract. Among the duties that an agent had toward the principal, we had LOADS, loyalty, obedience, accounting, disclosure, skill, care, and diligence. Slightly different versions in your book for disclosure and skill, care, and diligence, but still the same if you want to use the loads, LOADS, mnemonic. I'll give you a list and I'll change one of those, and you have to catch the one that I've changed. So if I change loyalty to lackadaisical attitude, that's the one, that's the answer. Okay? Last question. The duty of loyalty a real estate broker owes to the principal includes the duty or duties not to secretly profit from a transaction involving the principal, to return any such secret profit, and to disclose to all parties to a transaction that he or she is a partner, shareholder, or relative of any party to the transaction. Dun. There you go. All right. Anybody else who wants to see their grade, you're welcome to come up here and I will show you that.
I'm going to try to